remedies for breach of contract. So in this recording, we are going to be looking at the remedies for breach of contract, specifically damages. So wherever there is a breach of contract, wherever there is been a breach of contract and a party has failed to perform his obligations precisely according to the terms of the contract, and it's been established that there is a breach of contract, the next step is to determine what type of remedy would be awarded. So there are generally two types of remedies in contract law. And the first one is common law remedies, and the second one is equitable remedies. So in this recording, we're going to be talking about the different types and the different purposes and functions of damages as a remedy in contract law. We would distinguish between those different types of remedies and talk about the principles or the rules that govern the award of damages in contract law. Common law remedies, damages. So what is damage? When we talk about damages, what does it mean? It means a monetary compensation for loss caused by breach of contract. So whenever there is a breach of contract, it's damages is usually the most common type of remedy that will usually be granted by the courts. And so you would find that most breaches are best dealt with, by awarding damages. So damages are generally available as of right once it's been established that there is a breach of contract. So this is different from the equitable remedies where they are granted by the courts. It's up to the discretion of the court to grant or not to grant them. So they are not, equitable remedies are not granted as of right. They're optional. They're open to the courts to exercise the discretion to either grant or not grant. But damages are available as of right. So once it's been established that there's been a breach of contract and the party has suffered loss, and that party is entitled to damages. So damages for breach of contract is designed to put the injured party, so far as money can do it, in the position that they would have been if the contract had been performed, right? So the aim of damages in contract is to put the injured party, in the position that they would have been if the contract had been performed properly. This is different from damages in torts. Damages in torts is designed to put the injured party, as far as money can do it, in the position that they had been before the contract was made or before the contract was formed, before the breach happened. And this damages in torts generally extends to fraudulent and negligent misrepresentation, which I'm sure you've already dealt extensively, when you learned misrepresentation. But in this recording, we're going to be focusing primarily on damages in contracts. So damages in contracts is simply to, compensate the party and not to punish the party who, the party who caused the loss or who breached the contract. The aim is not to punish, it's not punitive in contract law. The aim is not to enrich the innocent party, right? So the aim is simply to compensate the innocent party. So although damages is in contract law is as of right, it is, not indiscriminately awarded, right? Or else it would cause a lot of hardship. So just because it's as of right does not mean that the courts will just award any amount of damages to anybody simply because they have proved that they suffered loss. Of course, you would receive some sort of damage, right? But what is the amount of damage that you would receive? So these are the things, so the law has put in place certain limits in order to ensure that damages are not just awarded indiscriminately. These rules are put in place to ensure that there is some sort of balance and to also ensure that that the innocent party is not being enriched or that unnecessarily or that the party in breach is not being punished, right? So the aim of contract law is always to put the party in the position that they would have been if the contract was performed. So these rules aim to be able to help the court to decide, to determine whether damages would be awarded in the first place and, what amount of damages would be awarded. And these are causation, remoteness, and mitigation. So we would start with causation. Causation seeks to reduce or to restrict the amount that is payable as compensation in breach of contract. So once it's been established that there's been a breach, right, the next question now is, did that breach result to a loss? Did that breach result to a loss? So the claimant has to show that he had suffered a loss as a result of the breach. And that if the claimant has not suffered any loss, right, he is not entitled to a humongous amount of damages. He's not entitled to a lot. He can only recover nominal damages. So a claimant who did not suffer loss. So just because the claimant suffered breach does not necessarily mean that the claimant would also suffer loss, right? So a claimant who has not suffered loss would only be entitled to nominal damages, which is a small amount of money, that compensation that will be granted. So loss can be classified as either pecuniary or non-pecuniary. So pecuniary simply means financial loss. It can be quantified in money, right? Non-pecuniary losses are non-financial losses, losses that cannot, that are not financial in nature. So, as I said, damages is designed to compensate, right? Not to enrich, not to provide gratuitous benefits to the party who has suffered the loss and not to punish the other party who is in breach, right? And so, let me give you an example. So, where there has been a breach, which has not resulted in a loss, right? The party can only be entitled to what? Nominal damages. And there are instances where a breach of contracts, might not necessarily lead to loss. For instance, where a party who has sold something, where the seller sells a car to the buyer, right? They entered into a contract to buy and sell a car. And the buyer eventually breached that contract and did not pay for it, for the car. So the buyer is obviously in breach, right? But the seller immediately sold the car to another buyer, another person who was ready to buy for a higher price or even for the same amount of money. So you see that even though the previous party, the previous buyer breached that contract, there was no loss that resulted because it was eventually sold and the seller, recovered the same amount of money or maybe even higher. So there was really no loss. So in such a case, the court would not grant a lot of damages, rather the court would grant what we refer to as nominal damages. So once it's been established that there's been a breach, the next question is, did the party, did the breach result to a loss? So there are different types of losses, right? There are the pecuniary losses and there is the non-pecuniary losses. So the pecuniary ones are the financial losses, right? And these are recoverable. The non-pecuniary losses are losses with respect to things like, harm to a person's feelings, disappointment, humiliation, mental distress, inconvenience, loss of enjoyment. So the general rule is that non-pecuniary losses are not recoverable, but pecuniary losses, right, which is like example is loss of earning. If I enter into a contract with you and because you did not perform a particular contract, I couldn't go to work, right? So I lost my earning for that day, right? Or maybe you were supposed to drive me or to fly me to somewhere, you breached the contract, right? It means that there is a pecuniary loss there, which is the airfare that I paid and maybe the hotel that I booked, right? So pecuniary losses are those losses which a party that which has, which has a financial undertone, which is financial in nature, right? For instance, loss of earning, loss of profit, the cost of repairing, a breach, curing a breach, expenses that a party has incurred due to the breach of a contract, where a property has been lost or things like that. So those are pecuniary losses and they are recoverable. However, the non-pecuniary losses are not exactly recoverable. And okay, so what is the general rule? Pecuniary losses are recoverable and non-pecuniary losses are generally non-recoverable. However, there are exceptions to this general rule that non-pecuniary losses are not recoverable. And you would see that in the case of Jarvis and Swan, Tours and Roxley Electronics, and construction versus faucet. So let's start with the first one. Jarvis Tours Limited. Facts of the case. Mr. Jarvis booked a holiday, right? It was supposed to be like a ski holiday, and he booked it through Swan Store Limited. And, in their brochure, they really described a very fun kind of holiday, right? And, he was supposed to enjoy a lot of benefits and enjoyment from that holiday. However, when he got there, he was very disappointed because there were very few guests, unlike what they promised. They promised that there would be a lot of guests. So it turned out that he spent most of his time, alone. The food, the entertainment was poor. So it was really, misleading. And remember, and so Jarvis sued for breach of contract, and he claimed damages for loss of enjoyment. And so the question before the court was whether a claimant can recover damages for non-pecuniary losses like disappointment, distress, or loss of enjoyment following the breach of a contract. Remember that the general rule is that for non-pecuniary losses, right, damages is not recoverable. However, there are exceptions, and one of the primary exceptions is where the sole purpose of that contract is pleasure or leisure. And in the case of this Jarvis, you would see that the sole purpose of that contract was pleasure and leisure. And so, Lord Denning, in that case, as stated that Jarvis was entitled to damages, not only for the cost of the holiday, but also for the disappointment and the distress that that the breach of contract cost him. So the court awarded him damages, and that damages included non-pecuniary losses, which is the loss of enjoyment and mental distress. And Lordeni went on to state that when a contract is made for pleasure, for relaxation, or for peace of mind, that damages for distress and disappointment is recoverable. So you can see that this is a clear example of exception to the general rule with respect to damages. Then the next case is Roxley Electronics and Construction against Foresight. So what happened in that case is that the claimant entered into a contract with a construction company to construct a swimming pool, for his own leisure, right? So to construct a swimming pool, and the swimming pool was supposed to be like 7 feet 6 inches deep, right? The deep end was supposed to be like 7 feet 6 inches. But then after the company had constructed it, he found that it was just like 6 feet instead of 7. So 6 feet 9. So the claimant brought an action, for the cost of the construction. The claimant brought an action for the cost of the construction. And, the question before the court was whether the claimant should be awarded cost of reinstatement or only nominal damages for loss of amenities. Because according to him, he felt unsafe whenever he entered into the pool, whenever he tried to get in the pool, he felt unsafe. And so he was now seeking, he was seeking damages to be able to reconstruct the pool, to rebuild that pool up to the specification that he wanted. Because but then, the court found that the pool was actually safe, even though it wasn't up to what 7 feet 6 as he wanted, but that there was no serious issue and it did not affect the value of the court. So usually in such a case, because it didn't affect the value of the pool, it should only be entitled to nominal damages, since the breach did not even it didn't reduce the market value of the pool. But then, the court held that, Mr. Fawcett was not entitled to the cost of reinstatement, because the cost of reinstatement was going to be a lot. It was going to be like £21,000. And you can see in those days, even currently, that's still a lot of money. So the court held that it was unreasonable, and so that he couldn't recover the amount of money he was seeking, which was £21,000, to be able to reconstruct the pool, because the court held there's no loss of market value. It's not really that bad, right? But what the court now did, was that the court now awarded him £2,500 as damages for loss of amenity, right? Because the court recognized that he was disappointed, and that although the general rule says that non-pecuniary losses are not recoverable, there are exceptions. And in this case, the aim of entering into that contract was to be able to have pleasure and leisure. And the fact that he lost the amenities and the way he wanted it exactly, the court at least granted him £2,500 as damages for that loss of enjoyment. So you would see that even though, damages is as of right, the court also has some sort of discretion, not with respect to whether to grant damages or not, but with respect to how much of the damages should be granted to a party. In this case, the court found that, granting Mr. Fawcett damages to reconstruct the pool was going to be too expensive. So it granted, Mr. Fawcett damages for the non-pecuniary losses that he suffered. So the next principle is remoteness, right? So this principle really places kind of like a limit, a very tight limit on recovery of certain types of losses. Remember that causation is that was there a breach? Did that breach result to a loss, right? So now, if it's been established there was a breach and the breach resulted to a loss, the next question is, what type of loss? There are different types of losses. There are certain losses that are very direct, and there are certain losses that are very indirect and unanticipated by the parties. The very direct losses is, for example, I enter into a contract with you to supply a car or to buy furniture, right? Or to buy, what else do people buy? Clothes, to sell clothes to me, and you breach the contract, you don't sell the clothes, but I've transferred the money to you, right? You can see that the fact, if I go to court and sue and ask for damages for your breach of contract, for ask for damages so that I can be put in the position that I would have been if the contract was performed well, right? That's direct, is expected. However, if I sue you and state that because you were supposed to sell a dress to me and you breached your contract and did not sell the dress to me, it meant that so I'm going to sue you. I'm going to sue you for the loss of unemployment, or the fact that I didn't get a scholarship or I didn't get a grant that I was going to apply for wearing that dress. Or I didn't win a lottery award wearing that dress. So you can see that, you will be asking from where to where, how? I only entered into a contract with you to sell you a dress. Why am I being asked to pay damages for loss of business? What does selling a dress have to do with business? So you see that there is no natural connection between that loss and the consequence. So for the principle of remoteness simply tries to limit the types of losses that a party should be expected to provide to provide damages for. So what kind of losses should the claimant be compensated for? Is it all kinds of losses? The answer to that is no. It would be really unfair for a defaulting party to be expected to provide compensation for all kinds of losses, irrespective of where, if there's a connection or not between the breach and the loss. And so um, to be able to determine whether the loss is direct, it should be compensated for or not, right? The court in the case of Hadley and Baxendale developed, certain rules. It developed like it laid down two rules that can be used to determine whether the loss is a direct consequence of the breach or whether that loss is too remote and therefore does not warrant compensation. So in the case of Hadley against Baxendale, Hadley instructed Baxendale. Baxendale was like a transporter, a courier, right? So Hadley instructed Baxendale to go and deliver a crankshaft to the repairer, to someone who was supposed to manufacture or produce a replacement. And Baxendale Hadley was to, the transporter was to, that's Baxendale, he was to take the old one to the manufacturer, right, to be able to use that old one as a model for creating the new one. But he delayed, he caused a lot of delay in delivering, in delivering the crankshaft. So when he eventually returned the crankshaft, right, the claimant brought an action. The claimant brought an action. And the primary thing that the claimant was asking for was that, that they lost, that the delay in delivering the crankshaft, right, meant that they had to shut down their mill because they had a mill, right? And they had to shut down their mill for an extended period of time. And so it meant that they suffered some loss of profit during the delay. So they brought an action, in court to be able to recover damages for the loss of profit during the delay, in transporting the crankshaft. So the question before the court was, whether that the question before the court was whether the loss was a direct consequence of the breach, right? The fact that I didn't deliver the crankshaft when I was supposed to deliver the crankshaft, was there enough connection? Was it a direct consequence of the breach? And it was held that the loss of profit was really not recoverable because the damages did not flow directly from the breach of the contract. Neither did the claimant explain to Baxendale the consequence of not delivering the goods, quickly, of not delivering the crankshaft in time, right? So Baxendale was not aware, that the fact that he was taking his time was going to cost the claimant business. It was going to make them to close down their business for a period of time. So he was not aware, and it didn't flow naturally. And so what happened in that case was that the court now laid down two rules, right? With respect to the court laid down two rules that should be adopted when determining whether the loss is too remote or not. And the first one is, the damages. Is it too was the damages, the damages arise naturally from the usual cause of the, from the usual cause of um from the usual cause from the breach, right? The damages arise naturally, and this is usually referred to as the normal losses or ordinary losses. So the first thing that the court in Hadley and Baxendale, the first thing that the court says, requires to be considered is whether the loss, whether the loss arose naturally from the breach, right? And the second one is whether the loss, which did not arise naturally, whether it was in the reasonable contemplation of the parties. So the first one is, did the loss arise naturally? If the loss arose naturally, of course, it's recoverable, right? But then if it did not arise naturally, if it's too remote, there is too much remoteness between the loss and the breach, right? It's not it's an abnormal loss, right? It's not something that would have been contemplated by the parties naturally, which means it's abnormal. It's a special loss. The next thing is, was the party aware? Did the party know that the breach will result to the loss? Was it within the reasonable contemplation of both parties at the time of the contract? not after the contract has been formed, but at the time of the contract, that the breach would result to a loss. In other words, if there's been a breach of contract and a loss has occurred and a party has brought an action, right? The court should first of all determine whether it's one that flows naturally, whether it's a normal type of loss. For instance, I didn't buy it, you didn't deliver the dress, so you need to repay the money that you owe, right? It's natural, it flows naturally. It's expected that if you enter into a contract and you don't perform, you will pay damages for not performing, right? That's natural. In such a case, of course, you can recover damages. However, where it is abnormal, where it is like a special type of loss, you didn't deliver the clothes, you didn't deliver the dress to me as agreed, right? And so because you didn't deliver the dress, I didn't go for the interview. I didn't have any dress to wear for the interview. And because I didn't go for the interview, I did not get the job. And because I didn't get the job, my mother or my dependents, did not have money for food and hospital bill. And so you want to now sue for a lot of those damages. You can see that it doesn't flow naturally. So the court is saying that if it flows naturally, of course you can recover. If it doesn't flow naturally, it's abnormal, right? You can't recover except you can show that it was in the natural contemplation, it was in the contemplation, in the reasonable contemplation of the parties. What do you mean by reasonable contemplation of the parties? It was either brought to the party's attention, it was communicated, the circumstance was communicated to that party at the time of the contract. So I can only sue you for the loss of scholarship if I had told you as the seller that, you see this dress, I need it to be able to go for an interview where I would be able to get a scholarship, or I'll be able to, get a grant, right? And that if you don't deliver it, I won't get that grant, I won't get that scholarship. So when you mention or when you communicate that to the other party is aware of the consequence of the breach of their contract. And so such special circumstances can now be recoverable, even if you don't communicate it expressly, by words. If it's the type that a reasonable man would know that this is the natural consequence of that breach of contract, then of course it would be recoverable. And this was laid down in the case of Hartley and Baxendale, and it was affirmed in the case of Victoria Laundry Limited against Newman Industries, Heron 2, Persons against Otley Ingham. So we would look at some of those facts. We'll look at the cases to be able to see if we can understand, if we can understand more about this. So we'll start with Heron 2. Kaniko against Kufos, Heron 2. So what happened in that case was that the claimant entered into a contract with the ship owner, right, to transport sugar from Romania to Iraq. So the contract, specified that the goods needed to be transported with so much speed, with all convenient speed in quotation, right? So the contract specifically stated that time was of the essence and I needed to be delivered to be delivered on time because according to, because market in the place of delivery is volatile, it changes, it fluctuates, so time was really of the essence. And so the ship, instead of delivering the goods in an expedited manner as requested, the ship, owner delayed delivery by 9 days by taking unnecessary routes and detours, right? So it delayed delivery by 9 days. So during that delay, the price for sugar skyrocketed, right? And so what happened was when the claimant now sold the sugar in Iraq, he did not now recover as much profit as he would have recovered if the contract had not been breached, if it was delivered within the time that it was supposed to deliver. So the claimant brought an action for loss of profit due to the price did not skyrocket, the price dropped and it caused him to lose, profit. And so the question before the court was whether the loss of the profit, due to the drop in the price of sugar, whether it was too remote. Because of course the contract was for delivery, it was a delivery contract, right? Was it too remote that he's now being sued for loss of profit instead of for not delivering the goods when he was supposed to? And the court held that the loss was not too remote, right? That the ship owner was liable because he was informed, it was communicated to him that the sugar needed to be delivered in a very expedited manner because of the fluctuations in market prices. So he was aware, it was within his reasonable contemplation, it was foreseeable that if he delays, the price could actually drop, right? So the court, held that, that it was not too remote and it was therefore recoverable. And in the case of Victoria Laundry, what happened in that case was that Victoria Laundry, had a commercial laundry business, and they now bought a boiler from the defendant, Newman Industry. The boiler was meant to help them to be able to take on more orders, to be able to perform their job, efficiently. However, it was delayed. Delivery of the boiler was delayed by 5 months. And, due to the delay in the delivery of the boiler, they lost business. And they also lost a very lucrative government contract. And so the company brought an action for damages for the loss of the business, profit, and the loss of the lucrative contract. And so the question before the court was whether the loss from, from the missed profits, especially the one from the government contract, was too remote to be recoverable, right? And what happened there was that the court said yes in the first question and no in the second question. So it said that, that the Victoria Laundry could recover damages for the loss of business because, it was expected that, if you don't deliver this boiler, you should know that if you don't deliver the boiler, that they might not be able to make as much profit, right? So the court said for that case, it was foreseeable. So there was a connection, right? It wasn't too remote. But then in the second part of the claim, with respect to the government contract, the government dying contract, the court held that it was too remote, that it could not have been within the contemplation of the company, right? And also the claimant did not inform the defendant of this contract, so that it was too remote and they couldn't recover damages for that part of the contract. The same happened in passing against Otley Ingham. So what happened in that case was that a man contracted a vendor, right? Someone that makes storage facility for hoppers. So, the claimant was a pig farmer. So he had lots of pigs, And instead of he decided to get a storage hopper, a food storage, so that it can dispense food to the pigs automatically. So the person who they bought it from came and installed the machine, right? But then he didn't install it very well. He did not install it very well. And so the pigs were not well fed. In fact, it wasn't dispersing the food, the hoppers, the way it was supposed to. And air was not getting in properly. And so those hoppers, the food started spoiling. They started developing mold, right? And person, who is the claimant, felt that it might not be a big deal. Unfortunately, 254 pigs in his farm died because they got infection from the moldy food. And so the claimant brought an action for, for the cost of the pigs that died, for damages for the loss of the pigs that died, and also for damages for loss of profits. So it went before the court, and the question was whether the claimant could recover damages for the loss of the pigs and also the loss of profits. And the court held that the claimant could not recover damages for the loss of the pigs, right? Because it wasn't within his contemplation that that providing a dispenser that is not that is open, because he was supposed to close. He was supposed to leave it open, but it was closed, and so he wasn't getting air enough. That delivering a ventilator or a technology that was closed would cause will cause his client to lose all that pig. And so the court held that it was too remote. It didn't flow naturally, and he too was not aware of the consequences of the breach of contract. So in summary, damages can only be recovered if it's not too remote, if it flows naturally. But then damages that are too remote can be recovered. Okay, generally they can be recovered, but now they can only be recovered if the party in breach had, was made aware of the special circumstances that that his breach would result to, right? At the time of the contract, he was made aware and he agreed to accept that risk of loss. That is the only time it can be recoverable. So now mitigation, which is the third principle, right? So the law imposes a duty on the injured party to take reasonable steps to mitigate their loss, right? So if there has been a breach of contract and that breach of contract appears to lead to a loss, right? There is a duty on the innocent party to take reasonable steps to prevent, further loss, to mitigate the loss that was caused by the breach of contract. For instance, if um, if I enter into a contract with you to buy and sell something and you don't deliver, instead of sitting down and waiting for, to go to court, right? I have a duty to try to sell the goods to somebody else. That way I'm mitigating the loss that I'm going to suffer. So this was enunciated, this can be found in the case of Brace and Calder and Taco against Kaduna North local government. So to be able to calculate the what compensation, the amount of compensation that a party is entitled to, right? The court uses what is referred to as measure of damages. How much will be adequate to compensate the claimant? To be able to answer that question, the court utilizes two primary ways. Two primary ways, and they are the expectation loss and the reliance loss. So the primary measure is the expectation loss, right? So it seeks to find out, what the claimant expects to have gotten from that contract, right? So the damages is calculated to give the claimant that benefit that they would have gained if that contract had been performed, properly. And the second one is the reliance measure, right? What it aims to do is to cover the cost that the claimant incurred in reliance to that contract. So if the claimant, while relying on the contract, had incurred some losses, right? If the claimant had incurred some losses, right, this is the reliance loss seeks to refund that claimant or that plaintiff for all the expenses that he could have incurred. This is referred to as the wasted expenditure. It seeks to put the claimant in the position that they were before the contract was made. This is different from the expectation loss, which is, strictly in compliance with, the primary aim of damages in contract law, which is to restore the parties to the position that they would have been if the contract had been performed properly. So expectation loss seems to compensate the party who has suffered loss by putting him in that position, right? So it refers to the profit that, by providing him with that profit that he was expecting to have received if that contract had been performed, properly. So the general rule is that the general rule as to time of performance is that the calculation of the damages should be done according to what is known or what was known at the time of the breach, right? Not, what was known or what is known at the time of the contract. And the reliance loss, as I said earlier, is kind of contrary to the general aim of damages, right? The reliance loss seeks to refund the parties of all the expenses. And this includes expenses incurred before or in anticipation of making that contract, right? Provided that it's within a reasonable contemplation of the parties. So it seeks to put the claimant in the position that they were in before the contract was made. So now types of damages. So there are different types of damages. There are the liquidated damages and the unliquidated damages. There are the general damages and the special damages. So liquidated damages are those predetermined amounts which the parties had agreed upon at the time of the contract as recoverable in the event of a breach. So you would see that most, contracts, when the parties are negotiating, some of them include liquidated damages. You would see a clause in the contract that says that if you do not perform your obligations, if you breach the contract, you will pay this amount of money. So Liquidated damages are those damages, is that amount of money that the parties are already agreed in their contract that the party in breach would pay. So the aim of liquidated damages, clause is to ensure certainty, right? Not to punish the parties. So it's not supposed to be punitive, right? But to ensure certainty. So the parties to a contract, can be able to ascertain or to anticipate, the cost, what it will cost them to breach the contract. Because sometimes it makes probably economic sense for some businesses, or more business sense for some companies to breach the contract. If they had entered into a contract before and had found a different one, sometimes it might even be more profitable for them to breach that contract and pay damages. So, but then it's important to include that clause in the contract so that the parties can be sure, what they're dealing with. So parties to a contract might actually anticipate the possibility that there might be a breach, right? And so when they anticipate this possibility, they could include a term or a clause in the agreement that a certain amount of money should be paid to the injured party, by the party in breach in the event of the breach. So liquidated damages is that sum that's already been fixed by the parties to compensate for loss that had been suffered. So for liquidated damages to be recoverable, it has to be constructed, it has to be drafted, as a genuine pre-estimate of the loss. It has to be, it has to be constructed as a genuine pre-estimate of the loss that the parties would likely, suffer. So if the sum is higher than, the genuine pre-estimate, or grossly overstated, right, overestimated, then the court would likely regard this arrangement as a penalty. Because remember, the aim of damages in contract law is not to penalize the party in breach, but to compensate. So if the liquidated damages that the parties have agreed upon, right, if it turns out that it's too high than um than what should be pre-estimated, it's too than it's not genuine, it's overestimated, right, then the court would not enforce such an arrangement because it would consider it to be a punishment to the defaulting party. And remember that the aim is not to punish but to compensate. Therefore, if you are drafting a contract and you want it to really be enforceable and there is liquidated damage, make sure that it's a reasonable amount there. It is genuine. It's not just as a punishment or as a deterrent to the other party, who would likely breach the contract. So where damages are unliquidated, the court determines the amount that is recoverable. So if it's liquidated, that's fine. If it's liquidated and it's genuine estimate, that's fine. The court will grant it. But if it's unliquidated, in other words, the parties they don't have any specific amounts that they've stated in their contract that would be paid by the defaulting party, it would now be left to the court to determine the amount that will be recoverable as damages. So the main difference between liquidated damages is the main difference, right, between liquidated damages and unliquidated is that one is stated in the contract, the other one is not stated in the contract. So remember that, if it's too high, if it's not genuine, then it might not be enforceable. It will be considered a penalty and not, a liquidated damage and not a genuine estimate. So the main difference is that liquidated damage is supposed to be a genuine pre-estimate, of the actual loss. But then a penalty, that penalty damages is likely to be is more like a punishment to deter, to discourage parties, or to punish the defaulting party for breaching the contract. And then, it's important that you remember that the court will only enforce an agreement. The court would only enforce an agreement which, which is for damages and not for penalty. And the locus classicus for this is Dunlop pneumatic tires, right? Dunlop pneumatic tires against New Garage Motors Company. And, the general, irrespective of the expression used in the label, whether the clause is stated to be a liquidated damage or a penalty, right? It doesn't matter. What the court does is that it examines the circumstance of that contract. It looks at the language of the party, the language of the contract, in order to interpret whether, that clause is liquidated damage or penalty. And so in the case of Dunlop, right, the court suggested some rules that should be used in determining whether the agreed amount, the agreed sum, is actually liquidated damages or penalty. And I'm sure you remember the facts of the case of Dunlop, the manufacturing company that supplied goods to defendants. And in exchange, for trade discounts, the defendants, undertook not to tamper with the mark on the goods. Yeah, not to sell and also not to sell the goods below a stipulated amount, right? And not to supply the goods to certain people. They named certain people. They should not supply to those people. And also not to exhibit or export any of those goods, right? So they made all these promises in exchange for a discount. But then the defendant, in this case, New Garage, right, defaulted. And so the company brought an action to recover damages, right? And the damages was £5, but that was in 1915. And the court held that the damages that they were trying to recover, even though it was already stated in the contract, and you know that liquidated damages is that it's been stated in the contract. So it was supposed to be liquidated damages, but the court held that £5 was too much. And so it was not going to recover, it was not going to consider £5 as liquidated damages, but rather it would consider it as a penalty, irrespective of what you named it, right? The fact that it's genuine is higher, it's not genuine, then the court decided to interpret it as penalty. However, the House of Lords reversed the decision of the Court of Appeal. And then the court suggested certain rules, right, that could be used to determine whether the agreed sum should be a penalty or liquidated damages. And the first one is that, the agreement, the amount of money would be held to be penalty if the sum provided for is extravagant in comparison with the greatest possible loss. We've stated that, right? It needs to be genuine. It can't be extravagant. Then the second one is that there is a presumption that it is a penalty when a single lump sum is payable for the occurrence of one or several events, irrespective of the degree of the loss. So it's stating that if there is just an amount that have been stated, and in determining the amount, in fact, that amount just covers any type of loss, whether it's a big loss or a small loss or a tiny loss, or it doesn't matter. It's just one lump sum that's been agreed, and it applies across board, that would be considered a penalty. And the third one is that the fact that a case is difficult to assess The fact that a case is difficult to assess with precision the damages or the loss suffered by the parties is an indication that the pre-estimate presents a genuine attempt to estimate and overcome the challenge of proving in court. So the next one is general and special damages. So general damages are those damages which, the law implies in every breach of contract and in every violation. So it is the loss that flows naturally. Remember, we talked about losses that are direct, that flow naturally. So once, it is the loss that flows naturally, there is no need to be proving anything, right? It's the loss that flows naturally from the breach of contract. And its quantum, does not need to be pleaded or to be proved. It is generally presumed by law. So it's usually awarded in most cases. And, there is no precise measure that can be used in assessing, the amount of damages. So it's usually assessed or qualified by relying on what, would be the opinion, right, or the judgment of a reasonable man. So he uses the reasonable man as a yardstick to be able to qualify or to assess, how much to pay. So the court may also take into account the motives of the parties in default, when determining how much to award as general damages. Special damages, on the other hand, are specific or peculiar losses that are suffered as a result of the wrongful act of the defendant. So, there are those specific losses that are recovered, that are suffered. So, general damages are the ones that flow naturally. Special damages do not necessarily flow naturally, right? So they are very specific, and so they need to be pleaded, they need to be proved. So for special damages to be awarded, there must be credible evidence which provides, specific details to prove that specific damages has occurred. So in NBBB company against ACB, the court stated that it's strike law that where the claimant specifically alleges that he has suffered special damages, he must prove it. The method of such proof is to lay before the court concrete evidence demonstrating in no uncertain terms, easily cognizable, the loss and damages he suffered. So what this is all saying is that if you suffer general loss, you don't need to plead it. You don't need to provide evidence to prove it. It flows naturally, so the court is aware, right? But if it's special damages, you see it doesn't flow naturally, so you need to plead it. You need to prove it. You need to provide evidence to be able to show and to sway the court to grant you those damages. So a damage is special in the sense that, it's easily, it's not easily discernible, it's not easily quantifiable. Example is the case of British Airways against Ayotebi, where, the court stated that, there are certain damages that are special, right? For instance, in that case, what happened was that the claimant um, was supposed to travel with British Airways. So Atoyebi he is a senior advocate of Nigeria, so he booked a first-class ticket on British Airways to fly to London. Okay, from London Heathrow to Lagos, right? On arriving to Lagos, he found that his luggages did not arrive with him. And so he brought it to their notice, right? To the notice of the airline. So during in one of the several visits where he went to the British Airways office to complain about his luggage, he was informed that his bag had been authorized to be collected at Heathrow, but that British Airways refused to hand over the bag, right? Because he sent someone actually to Heathrow to go and pick up the bag, but British Airways refused to hand over the bag. So he had to travel back to London for the sole purpose of collecting his bag. So he at London Heathrow, British Airways employee met with him there and handed over his bag to him and gave him his bag, right? And he found everything was intact. So when he came back, he brought an action to seek compensation, to seek damages for the breach of contract and the fact that he suffered some special losses. So aside from the fact that they breached their contract, right? He suffered some special losses. So what happened was when he returned, they they promised to give him some money, right? But then he had his own claims. One was that he sought the amount of money back for the cost of the plane that he purchased, the ticket that he purchased to go back to Heathrow to go and pick his bag. That flows naturally, right? You breached your contract and I had to go and pick it up by myself. It's natural that you would refund me that. So that one doesn't necessarily need to be proved. He also sought to get a refund for the hotel for the hotel he stayed in London when he went to pick up the bag, the taxi that he took, right? He and his associate took, the telephone calls that he made, the professional time that he spent in UK while trying to pick up the bag. And he also sued for stress and inconvenience. And so from this list of things that I just stated now, you can see that the general damages are the ones that flow naturally. The special damages are the ones, things like the hotel stay. He needs to prove it. He needs to provide receipts as evidence of the amount of money that he spent and the period of time that he spent it, to show that it was really when he went up to pick up his bag. He needs to provide evidence for the taxi ride, maybe a receipt or something to show that he really took that taxi. If he's going to claim telephone calls and faxes, he needs to also prove it. So what I've been saying is that with respect to special damages, you need to be able to prove, special damages. You need to be able to provide evidence. So in contract law generally, right, the courts frowns at the categorization of general damages and specific damages. So this does not apply to torts, right? It doesn't apply to other types or other classes of law, but in contract law, right, where you're suing mostly on contract or exclusively on contract claims, right? The court frowns at the demarcation of general and specific damages. And the court also has criticized some contract cases as being inappropriate, as being misleading, and that some judges actually grant very excessive and extravagant damages. Remember that the aim of damages in contract law, not torts. Torts is different. In contract law is to put the parties in the position that they would have been if the contract had been performed properly, not to compensate and not to punish. So it's not expected that it shouldn't be extravagant. It shouldn't be excessive. So in the case of GKFI against NITEL, the court held that in the law of contract, there is no dichotomy between special and general damages, as it is in the position in torts, that the narrow distinction is often surmised as on without and different. In contract, it is damages simpliciter, right? So losses arise from the breach. And so what the court is doing, when it makes this pronouncement, is that it's actually trying to avoid double compensation. It's actually to avoid double compensation. So even though the court has criticized this categorization, it still continues, whether it's a contract or a tort. Usually the courts usually demarcate, between the special and general damages. But then, the reason why this is usually frowned at is because the court is trying to avoid double compensation, double compensation and injustice that might be occasioned by granting, damages to a party that has suffered loss that cannot be quantified. If it's not a direct loss, you need to quantify it, you need to prove it. So the rule of double compensation simply tries to prevent a party from claiming under two different heads, right? So you want to claim damages under general damages and also under special damages. So consequently, once a claimant is fully compensated on one head, the court says that the claimant should also not go and seek for compensation on the second head, right? So these are the cases where the Supreme Court have held in that the award of damages based on double compensation is erroneous in law. It requires courts to scrutinize the claim to avoid double compensation. So we've already talked about this British Airways against Atoyebi. These are the things that the claimant sought in court. So you would see that 1 to 5, right? That some of those things need to be proved, right? You need to show the ticket that you bought, because let it not be that you simply send someone to go and pick it up and you're claiming you bought tickets. You need to prove the ticket that you bought. You need to prove that, this is the amount of money that I usually earn on a daily basis. And the fact that it took me 3 days or 2 days means that I had to lose this certain amount of money. So you need to provide evidence for that. You went to a hotel, you took a taxi, you made telephone calls, you need to be able to prove all that. So you see that after all these things that's been listed from 1 to 7, there is also now 8, which is damages for stress and inconvenience of traveling, 100 pounds, 100,000 pounds. So you see that even that is already on a high side, right? So if the courts do not take steps to curtail this, it could lead to overcompensation, to excessive compensation of the injured party. So the next one is equitable remedies. So equitable remedies are those remedies which were developed by the courts of equity, right? They were developed in the English court system, right? In the court of equity, to be able to provide some sort of recourse and to reduce the hardship of the common law rule. So, specific performance is an order of court, right? Which aims to which seeks to is an order of court issued, which seeks to compel a party to perform his contractual obligation. So sometimes you find that damages would not usually be sufficient compensation, right? For instance, you have the privilege of entering into a contract with a very popular artist, right? And he decides to breach the contract. And you would find that if he pays damages, it's really nothing, right? It's nothing compared to having that person perform. So in certain cases, it's important to force that person to do what they have said that they would do. And that is what is referred to as specific performance. It's an order issued by the court compelling a party to perform his contractual obligations. So this could happen where there is an anticipatory or actual breach. For instance, right, a person says, repudiates the contract. He says that he would not perform when time for performance, arises. In such a case, the innocent party, Jesus, you scared me. In such a case, the innocent party could actually, go to court and ask the court to force that party to do what it is that they And so where the court eventually gives an order of specific performance, if the party, disobeys that order, the party could be in contempt of courts. So at common law, the primary remedy that the court will usually grant to parties is damages. We've said that earlier. However, there are instances where damages would not be adequate. And that is where this equitable remedy of specific performance or even injunction could come into place. So the fundamental rule is that the court would not ordinarily order specific performance, or even injunction or any equitable remedy at all. Remember, we said it's discretionary, unlike common law remedies, right? So the court does not have to grant it. And the court will usually not grant these equitable remedies where it feels or where it believes that damages would adequately compensate the parties. So in the case of Bestwick against Bestwick, the claimant's husband, sold his business to his cousin, who was to pay an allowance to him annually. So the cousin refused to make further payments when the claimant died, right? And when the claimant, died, and so the claimant had to bring an action, right, against the deceased, with the intention to make the deceased to continue to pay. And since the death of the husband, since the dead husband did not suffer any loss, by non-payment, the award of damages would have been very nominal because you know that there is causation, right? It needs to flow. If you don't suffer loss, you would not get a good amount of damages. You would only get nominal damages. And so it would be inadequate. So specific performance, the court held that specific performance was, the best bet, was best to use because, damages would not be adequate. And in another case, Harnett against Yielding. Yielding entered into a farming lease agreement with Harnett, right? Where he leased a land for 21 years and he paid 95 pounds per year. And there was a guarantee in that agreement that it would be renewed, for the rest of Harnett's lifetime. But Harnett later surrendered the lease because the rent was too high, right? And Yielding offered Harnett another lease for 21 years for a lesser amount of 80 pounds, right? So when Harnett's son tried to renew the lease, Yielding refused, stating that the new lease was only for 21 years. And Hannah took the matter to court, seeking specific performance. And the court, the judge, the Lord Chancellor, used this opportunity to set out, some guiding rules or guiding principles with respect to specific performance. The first one is that it stated that specific performance will not be granted where one of the party seeking specific performance is blameworthy. So a party who comes to equity must come with clean hands, right? So if you're blameworthy, the Lord Chancellor stated that you can't seek specific performance. The second one is that specific performance must be lawful. The third one is that the act to be performed must be certain, right? The act to be performed must be certain. And the court held that it was not certain if, in the new lease, if the new lease that was formed was not, if the new lease, right, did not contain a renewal clause, specific performance was not granted in this case. So from this, you can see that before granting equitable remedy, the court will usually ask, if damages is inadequate, because it would usually not grant them specific performance where damage would have been adequate compensation. The second one is whether the conduct of the claimant was, has been inequitable. You come into equity, you must come with clean hands, right? He who seeks equity must also do equity. Then the third one is overall justice. The court will not award specific performance where it is impossible to perform or where it would cause undue hardship on the defendant. For instance, if it's impossible to perform, maybe the death of the artist, or maybe what you're trying to make them to sell to you has already been sold to an innocent third party, it would really be unjust on that innocent party. And so in such cases, specific performance might not be, granted. So there are certain types of contracts that are generally unsuitable for the order of specific performance. But before we talk about certain contracts that might not, okay, let me still go ahead. So example of those contracts that might not be suitable for specific performance. The first one is personal contract of service, example, employment contracts, right? So the courts will usually be reluctant to force an unwilling employee on a willing employee on an unwilling employer. So, the court is really reluctant to grant specific performance in personal contracts of service. The court is also reluctant to grant specific performance in contracts which involves constant supervision of the court. So if it's going to require the court to spend time and resources to supervise and ensure the enforcement, continuously of that order, then the court would not do that. The court, would not grant specific performance where mutuality is not possible, right? For instance, where there is a minor that is involved. This means that, the courts will usually be reluctant to order specific performance against the defendant unless such an order would also be available to the other party, against the claimant. And, this might arise, for example, where the claimant is a minor and, won't be able to sign won't be able to be granted specific performance, to someone to compel him to do something. Then the third one is default of the other specific performance may result in imprisonment. We said that already. So remember that when talking about, specific performance, we've already stated that, but it's important that I restate it, that there are certain guiding principles, right? And the first one is what? Inadequacy of damages. The court will not grant specific performance if damage will be would provide adequate remedy. So where a replacement of, the subject matter of the contract, can be purchased very easily, right? If it's something that money can do, of course, why don't you compensate? You give that order for monetary compensation, except it is the type that money can really not kill, right? It's not easily purchasable. You can't purchase that exact thing very easily, you know. The specific performance can be granted. So specific performance may also be granted where damages alone will be inadequate compensation. We've said that. Contract for sale of land, right? The court in contract for sale of land, the court is of the view that every land is unique. So it's hence damages is usually not adequate. So specific performance is the one that is mostly granted in contract for the sale of land because the court believes that every land is unique. Then the second one is whether the conduct of the claimant has been inequitable. So a party who is seeking to enforce a contract must show that he has either performed or is ready and willing to perform, all the terms of his own obligations. As we said, he that comes to equity must come with clean hands, which means that if there is something that you're supposed to do with respect to that contract, before you start asking for specific performance, you need to ensure that you have done everything that you were supposed to do as a party to the contract. If you are in breach of your own obligations, you will not be granted specific performance, right? And so in Afrotech Technical Services against Mia and Sons Limited, right, the respondent claimed for specific performance at the Supreme Court, but it wasn't successful. So the party sought specific performance. The party that sought specific performance had only performed part of his obligation, by making 60% of the payment. He had not yet made, 100% of the payment. And so the court held that he wasn't coming with a clean hands. He hadn't performed his own obligations fully. In Coca against Ajowale, in Coca against Ajewole, the plaintiff claimed that specific performance did not succeed because she did not complete her own part of the contract. The plaintiff's claim of specific performance did not succeed because she hadn't performed her own part of the contract. She was to pay like £1,175, but she only paid like £800. So the respondent, had to source the remaining to be able to complete the building. And after completing the building, the respondent rented the building to someone else, and she brought an action for specific performance, asking the court to force the respondent to actually rent or lease the building to her as agreed, right? But the court held that she didn't come with clean hands. She hadn't completed the payments as she undertook to. She had only made 160% deposits. Then the court would also not award specific performance where it is impossible to perform or where it would cause hardship to the defendants. For instance, in Taylor and Russell, the West African Court of Appeal refused to grant specific performance on grounds that it will cause hardship and will be impossible to enforce. This is because the land or the subject matter of the contract had been sold and resold to other buyers, innocent buyers who gave value for the sale. In Patel and Ali, the claimants requested specific performance for a contract for the sale of house, but the courts awarded damages instead, based on the grounds that because the defendant had become disabled and her husband bankrupt, they both need to be close to family and friends, and moving away from the house will cause hardship. So the next type of equitable remedy that we'll be looking at is injunction. So what is injunction? Injunction is a decree, is an order of courts, ordering, instructing a party to do or not to do a certain act in accordance with the contract. So this type of remedy is rarely granted because, of course, the first one would usually be, damages. Then there are cases where injunction is necessary, right? So it can be used to enforce an express negative, to prohibit, right, a person from performing an act which would probably, not be beneficial to the other party. And of course, it's discretionary. And all those criterias, all those guidelines must also be followed. Those guidelines that we talked about with respect to specific performance, because they are both equitable remedies. So in all equitable remedies, you need to prove inadequacy of damages, that the conduct of the parties are coming with clean hands and overall justice. So the same applies for injunction. So in Warner Brothers against Nelson, an actress agreed to give her exclusive service, right, to the plaintiff for a certain period of time. And during the period of the contract, and also during that period of the contract, she undertook that she would not give her services to any other person. So it was like an exclusive service agreement. And however, she tried to breach it, right? She tried to repudiate that contract. And because she wanted to get another engagement, which was more lucrative, to her. So the claimant went to court for an injunction, for the court to order her, to restrain her from entering into that contract. So you see that it's different from where the court is ordering you to do what you promised to do. In this case, the court was trying to restrain her from performing an act. So an injunction, is where the court is ordering someone to do something or not to do something. In Whitewood Chemical Company against Hardman, the contract of service, had a term where the defendant undertook to give his time to the company. So the company sought an injunction to enforce that contract, to stop that, to stop the defendant from breaching his contract. However, the court declined on the basis that the contract did not contain an express negative stipulation. It simply stated that he will do, not that he will not do. So the express negative stipulation simply says that I will not do this, I will not do that. And so if you try to go against what you've promised, the party can bring an injunction to stop you from doing what you said, to stop you from going contrary to the contract, or to make you to do something in favor of the contract. There are different types of injunction, but that is beyond, the scope of this class. So the next one is quantum merit. This is where the price was, this is where the court orders that the amount proportionate to the work done be paid to the claimant. So this is where a party who has performed, some part of the contract, is seeking to be paid some amount, the amount that they have worked for, right? The amount that is proportionate to the work that they have done, to be paid for that amount on quantum merit basis. Okay. Thank you for listening. Thank you for your attention.